State of Texas versus Miguel Maldonado, represented by Ms. Kelly Green. This is a motion to revoke community supervision. Representing the state in all matters is Ms. Karina Sanchez. Representing the Bexar County CSCD is Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which is reportedly signed both by Mr. Maldonado and Ms. Green. In fact, Mr. Maldonado, is this your signature on this document, sir? Yes. And I think your microphone's turned off accidentally, sir.
Yes, Your Honor.
Thank you. And Ms. Green, as attorney for Mr. Maldonado, is this also your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Maldonado?
Yes, Your Honor.
And Ms. Green, as attorney for Mr. Maldonado, is this also your signature on this document?
It is, Your Honor.
Thank you. On the, Ms. Green, my understanding is this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes.
Mr. Maldonado, in cause 561218 on the motion to revoke community supervision, how do you plead, sir?
Guilty.
True. It'll be true, Miguel.
True.
Oh, true. Court accepts the plea of true. Ms. Gross, would you please advise the court and the parties of the status of Mr. Maldonado's probation?
Yes, Your Honor. Mr. Maldonado has been reporting out of county. He is paid in full. He was not assessed any community service hours. His Smart Start mobile device was removed 9/6/2019. He had 2 positives for UAs and 1 negative. One of the positives was alcohol, 1 was cocaine. He's completed victim impact panel, alcohol treatment program evaluation. He did the DWI education class, but he was supposed to do the DWI intervention class. This is his first violation report, first MTR. He has 1 prior arrest for possession of marijuana, 4 ounces to 5 pounds. And his officer is recommending revocation.
And Ms. Green, what are you requesting?
Your Honor, this case is a transfer from county court to the violations that the probation officer is referring to is 2019. That's 3.5 years ago. He did pick up a new number 1 in January of 2020, which was 2.5 years ago. He's been monitored since then. He's on probation. He's had the ignition interlock, he told me, for close to 4 years now, and will continue to have it on his vehicle for the next 1.5 years. He's completed his courses there and has had no violations since then. So we're asking the court to terminate his probation unsatisfactory.
Is Mr. Maldonado on misdemeanor or felony DWI probation out of county at this time?
Misdemeanor.
Misdemeanor? Okay. But this case is a DWI second, is it not?
Yes.
Right.
Correct.
Okay.
Correct.
Are you working, Mr. Maldonado? What are you doing?
Actually, I'm taking care of my daughter. My mother-in-law has stage 4 cancer, and my mom has a bulging disc. So I've been doing odd jobs here and there, but
Okay. State recommendation on Mr. Maldonado, please.
State would recommend that we term unsat, Your Honor.
Original fine was $500, Susan. Does that sound right?
Yes, Your Honor, that is correct.
Mr. Maldonado, on cause 5-6-1-2-1-8, the court accepts your plea of true. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bear County Jail. It says a $500 fine plus court costs, credit for time served, time and money to run concurrent. Your report to the Bear County Jail at 9:00 a.m. on Monday, July 18th, 2022 to serve your sentence. If he did any time in jail on the newest DWI, I'll be happy to give him credit for that also. I just need some sort of number to put in the order. Anything further from the state of the defense on Mr. Maldonado?
Not from the state, Judge.
And Mr. Maldonado, for the record, I could have put you in jail for a year, but your attorney convinced me that you did do some things and you did take responsibility for the new offense. So good luck to you, sir. And thank you, Ms. Green.
Thank you.
And we're also recalling all pretrial services, bond conditions, and warrants in this case. Okay, did we
Your Honor,
get,
Mr. Menchaca is coming on board, Your Honor. He's
Okay.
joining. He's trying to come in.
Well, if he can't have a stable enough internet, Judge, I can always call him on my phone and.
let's do that and just put him on speakerphone.
Yeah,
Okay.
and I saw him already. I mean, I have seen him. Your Honor.
You know, if it's okay with the state, it's okay with me.
Susan, you need
No
to go
objections,
back
Judge.
into the breakout room.
Yes, I was just gonna let you know I'm gonna go.
Okay.
All right, we still need Susan for one more case, right?
Yes, they're talking in the breakout room
I
right
got you.
now.
Okay.
All right, Mr. Menchaca, can you let the court know you're here?
Yes,
Can you hear that okay, Judge?
I can. Hey, Mr. Menchaca, try to speak up a little for us, but we can certainly hear you. For the record, would you please tell us your name?
Can you hear him, Isaac?
I didn't last part.
Can you state your name for the record?
Isaac Menchaca.
Thank you, sir. This is cause number 676-475, State of Texas versus Isaac Menchaca, represented by Ms. Therese Carter, representing the state in all matters, Ms. Karina Sanchez. I need to bring up a housekeeping issue. Mr. Menchaca's first name, Isaac, I-S-A-C, is misspelled 6 times on all the documents in this case. So Ms. Benavides, is you just ensure on the original that's corrected before it gets processed?
Your Honor, I have already notified the clerks to do so.
Perfect. Good to go. First document I have, Ms. Carter and Mr. Menchaca, is entitled Defendant's Consent to Plea by Video Conference, which purports to have both Mr. Menchaca's signature and Ms. Carter's signature on it. In fact, Mr. Menchaca, is this your signature on this document, sir?
Can you say that again, Isaac?
Yes, sir. It is my signature.
Okay. Thank you. And Ms. Carter, as attorney for Mr. Menchaca, is this also your signature on this document?
Yes, Your Honor.
Thank you. The next document I have, Mr. Menchaca, is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, sir, is this your signature on this document also?
Yes, sir.
Thank you. By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, Ms. Carter, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Fully understand.
Thank you. Ms. Carter, as attorney for Mr. Menchaca, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes, Your Honor. In my opinion, he is mentally competent, and I have had time to review the defenses in this case.
Mr. Menchaca, are you a United States citizen, sir?
Yes, sir. Yes, Your Honor.
Thank you. And Ms. Carter, has the state fully complied with discovery for you on this case?
Yes, Your Honor.
And let's see what we're doing here. Mr. Menchaca, and cause 676-475 to the charge of theft, $100 to $750. How do you plead, sir?
How much again?
How do you plead?
Ms. Carter, my understanding is Mr. Menchaca is going to enter a plea of no contest and cause 676-475 to the charge of theft, $100 to $750. Is that correct?
That is correct, Your Honor.
And Mr. Menchaca, is that correct, sir?
Yes, Your Honor.
All right, great. Thank you. State, is there an agreement for Mr. Menchaca?
Yes, Judge. Agreement is a $100 fine with court costs, 5 months deferred adjudication, an ATSE course, 35 hours of community service, and no contact with Walmart.
Is that correct, Ms. Carter?
That is correct, Your Honor.
Mr. Menchaca, on cause 676-475, the court accepts your plea of no contest to the offense of theft, $100 to $750. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 5 months, deferred adjudication probation. It says a $100 fine plus court costs. The ATSE anti-theft course order you to conduct 35 hours of community service and have no contact with any Walmart stores in San Antonio, Bexar County, Texas during the term of your probation. Anything further from the state of the defense on Mr. Menchaca?
Not from the state, Judge.
Nothing from defense, Your Honor.
If it's okay with the state, there's no problem on my side, Ms. Carter. If Mr. Menchaca finishes his probation before 5 months, we can early terminate him as far as I'm concerned.
I will review that with him, Judge, once he's completed everything and
I understand. All right. Good luck, Mr. Menchaca. Thank you, Ms. Carter.
Hold on, Terry,
Yes.
just let him know that he'll get a call from, or some sort of communication from probation within 72 hours. And if he doesn't, have him call 335-7446. And that's the intake section. And let him know that he was placed on probation and he needs an orientation department, or you can just reach out to me next week.
okay, perfect. I'll do that. Thank you, Susan. I
All
appreciate
right,
it.
you're welcome. You have a good day.
You as well, Judge. Are we excused?
You bet. Thank you so much.
Thank
What
you.
are Mr. Nalbach and Mr. Lopez charged with today? Is this another indecent exposure thing, Mr. Lopez?
Your Honor, that was in my early 20s. I've grown beyond that, sir. How are
Judge,
you?
I still had hair back then.
Are y'all here for the case we're in now, or are you here for something else?
We are in here for Miss Erica Small,
Okay.
cause number 675-581.
Are y'all ready to proceed on that at this time?
We are, sir.
And Mr. Dominic, are you going to be the primary attorney on this case?
I'll let Mr. Lopez do the talking, Judge.
All right.
But yeah.
This is cause 675-581, State of Texas versus Erica Small. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Ms. Small is Mr. Diego Lopez and Mr. Michael Dominic. The first document I have in this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Ms. Small and apparently Mr. Dominic's signature on it. In fact, Ms. Small, is this your signature on this document, ma'am?
Yes, it is, Your Honor.
Yes.
Okay, thank you. And Mr. Lopez, can you confirm that this is Mr. Dominic's signature on this as co-counsel?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote. In fact, Ms. Small, is this your signature on this document also, ma'am?
Yes.
And Mr. Lopez, can you confirm that this is your trial partner, Mr. Dominic's signature on this document also?
It is, Your Honor.
Once again, in clause 675-581, this is a motion to enter adjudication of guilt and revoke community supervision. My understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Would that be accurate, Mr. Lopez?
No, Your Honor, it is contested.
All right. There's two forms of contesting an MTR in my understanding. One we call a formal contest, in which point the only real difference is we attempt to get the original probation officer from CSCD to testify. Otherwise, Ms. Gross just reads off of that person's notes. And obviously she's under oath, but that, neither here nor there. If you want to have Ms. Gross try to see if we can find the original probation officer, you're welcome to do that. The second deal is format is it's not what I call fully contested, but you can still plead not true. And obviously you're still going to come to me as the trier of fact to make a determination whether I find any of these things are true or not true. And basically you just consent to doing it that way. The only real difference that I'm aware of is we normally call the actual original probation officer to testify if you want a fully contested motion. What would you like to do? Or would you like to go in a breakout room and chat with your client about the options, or how would you like to proceed?
Your Honor, I believe that we can proceed with the informal for Ms. Gross to read the report.
Okay.
And allow you to be the trier of fact with regard to the violations.
All right. Is that okay with you, Ms. Small?
Yes, sir.
All right. On the motion to enter adjudication of guilt and revoke community supervision and cause 675-581, Ms. Small, how do you plead?
Not guilty.
We mean not true. How about not true with an explanation? Would that be accurate?
Not true with an explanation, Your Honor.
Court accepts the plea of not true with an explanation on all conditions. Ms. Gross, would you please advise the court and the parties of the status of Ms. Small's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Small's only been on probation a little over 2 months. Her reporting has been good. We haven't had any issues with that. We last saw her on July 8th, 2022. She's paid $118 towards her fees, has a balance of $1,414 and is $50 delinquent at this time. We have no record of any of her 48 hours community service having been done. She's had 3 negative drug tests. She's completed DWI education and victim impact panel, and no record of completion of the CAT-SNP program. She is currently on a Smart Start mobile device in which she has had 9 skip tests and 19 high BRACs ranging from 0.021 to 0.071 that occurred as one instance. And those actual tests occurred early in the morning, and the first initial high BRAC that was recorded on the device occurred at, hang on, let me get to that time. My computer is not cooperating, at 7:55 in the morning, and then she did not blow to clear until 10:17 in the morning. Her officer is recommending that she be placed on a scram device.
So it's clear for all parties concerned. Basically, she is alleged to have violated the condition about not consuming alcohol in one day. You've alleged a bunch of different amounts of breath tests, but they're all on the same date. Is that correct?
Yes, it occurs to be one incident and not over any, great period of time.
Okay, in the future, if you counsel your officers, we don't really need all that. All we really need is whatever the highest blow that day was and any circumstances around that. This is just more work for your officers, and it doesn't really help us on an MTR hearing.
This was created by a brand new officer. I will have a chat with her.
All right. No, I mean, it's not life and death. It's just more work for her. And it doesn't really make any difference to us. All right. Mr. Lopez, what are you requesting?
Your Honor, may I share screen with the court?
Sure.
Thank you, sir.
You want to go in a breakout room? Is that what you want to do?
No, sir. I just want to share some evidence with you.
Oh, okay. Sure. I'm not sure how to do that. Pat can advise you.
Pat, if you could permit me to share screen. Thank you very much, Pat.
I'm not seeing anything on my side. Oh, wait, something's working. Okay, gotcha.
All right, Your Honor. If I could draw the court, just as the court has enumerated, and just as Ms. Gross has shared with you, there was one incident of high levels of the blood alcohol content. That occurred on June 2nd. This is found on the next to the last paragraph, Your Honor, on page 1. Is the court capable of seeing my cursor on the top right-hand corner?
I can, and for purposes of the record, if it's okay with you, let's mark this as Defense Exhibit 1 for identification for purposes of this hearing only.
Thank you, Your Honor.
You
Can
bet.
you see this, or would you like me to blow this up? a
No,
little bit
I see
more?
it. I see it fine.
All right, sir. Number 1, at 7:55 a.m., as the court has just noted, she had a blood alcohol content of 0.025. And that was the first recordation. And so there's zero change. Number 2, Your Honor, this device, 1 minute later, recorded her blood alcohol content at 0.070. 1 minute had elapsed, and that is a 180% increase in her blood alcohol content in 1 minute. The next reading was at 8:02. 6 minutes later, her blood alcohol content increased another point. That is 1.4% increase. At 8:19, 17 minutes later, her blood alcohol level had dropped by 0.004, which represents a 6.3% drop. At 8:31, 12 minutes after the last reading, it dropped down to 0.056, which represents a 16.40% drop. 11 minutes later, there's no change. 6 minutes later, there's no change. At 8:55 a.m., it drops to 0.051 from 0.056, which is an 8.92% drop. There's very little change for the next test at 8:55 and 8:56, but at 9:01, it drops more than 50%, Your Honor, from a blood alcohol level of 0.050 down to 0.022. That's in 5 minutes, Judge. That represents a 56% drop. This defendant must have Superman's liver in order to process alcohol in this fashion, because exactly 8 minutes later, it doubles. It increases by 109% to 0.046. Your Honor, this machine was not working on June 2nd, 2022. These are the numbers that are presented in violation of condition number 14. The court and Ms. Gross have both identified that this was the real problem. This was the date. And if the court were just to put a pencil and paper to it, which we have done for the court's benefit, in 1 minute, her blood alcohol level almost tripling, 180% in 1 minute, Judge. There's something wrong with the machine.
Let me stop you there, if I may, and ask Ms. Gross a question. The language used by the state in alleging violating condition number 14 says that the defendant submitted 19 high BRAC violations. Normally, when a defendant is using a Smart Start mobile device, initially they blow every 6 hours, so 4 times a day. And then after they blow each of those 4 times, if there's a high BRAC, they get prompted to blow again, which would be a second blow. So my question is, under what circumstances was this defendant blowing 19 times?
It will allow them to blow until they blow clear, and she continued to blow to try and clear the device.
Okay. I just never seen that happen before. Do you see that happen very often?
Well, usually it's not all listed on the motion for your request. Like I said, this is a new officer that was not aware of your policy.
I got you. Okay, go ahead, Mr. Lopez.
Your Honor, on the far right-hand side, you see the percentage change on this chart. An increase is identified in blue. A decrease is identified in red. At the highest point, Your Honor, her blood alcohol increased 180% in 1 minute. And at the lowest point, it decreased almost 50% in 8 minutes. There is a spread here of some 230%, Judge. And again, Your Honor, if we're using science and if we're using a device that is recording true numbers, it would be impossible for this defendant to physically have the capability of blowing these numbers. Judge Christian, this is one of those rare occasions when the device was faulty. And as the court has pointed out, this is the only date she has appeared. She has paid her fines. She is working double shifts to try to pay for everything. To force a scram device on her would also include additional expense. And she is, at this point, she's at the extent of her ability to pay, Judge. Mr. Dominic has done a wonderful job up to now, and I'm going to be taking over for Mr. Dominic. But, Your Honor, we're asking that the court permit Ms. Small to prove to the court that this was just a mechanical problem with this one device. By the way, Your Honor, my client informed the company that this thing was malfunctioning. She turned it in. She had to pay an additional $500 to get a new one. And since that last report, there have been no problems with her using this device. We're asking that the court reconsider the revocation of community supervision simply based upon the numbers here, Judge. Based upon the fact that she has only been on probation for 2 months and she's reporting as required, as Ms. Gross was kind enough to share with the court. She's doing everything that she should do. We just want a chance for her to finish out her community supervision, Judge. Thank you.
Let me ask the defense a few questions and then to clarify, is the defense position that Ms. Small did not consume any alcohol on June 2nd, 2022?
That is correct, Your Honor.
Okay, so the defense explanation for why we kept getting positives for alcohol in various amounts is that the machine must have been broken. Is that correct?
Your Honor, there's more to it than that. And if I could share with the court.
Go ahead, sure.
Your Honor, my client works in the service industry. My client is required to use hand sanitizer. And she keeps hand sanitizer in her vehicle, in her purse, in her backpack, at home, and at work. And we believe that one of the hand sanitizers broke open where she kept this device. And that hand sanitizer, as the court knows, is anywhere from more than 50% to up to 90% alcohol. And that's one of the reasons that she contacted the company and said, look, this thing is not working. Please, please, it's showing false positives. Replace it. That's why she paid the $500. And it's been replaced, Your Honor. And there have been no reports of violations since the replacement.
All right, let me ask some questions based on those representations. On what date, at what time did Ms. Small call the Smart Start Mobile company and report that her machine was malfunctioning?
If the court would give me a moment, I'll find that out for you right now,
Sure.
sir. Your Honor,
Yep.
the record with the Smart Start company will reflect that on June 2nd, the morning of the June 2nd, when she was getting all these false numbers, she called in that morning.
Okay, and who did she speak to? Do we know?
One moment, Your Honor. Your Honor, she spoke with two different representatives of the Smart Start company, whoever answered the phone that day, and somebody with some technical expertise. And they were both talking to her about trying to clear the machine.
And what, I assume during this conversation, they advised her to bring her machine in and so they could check it. Would that be accurate?
One moment, Your Honor. Negative, Your Honor. They instructed my client to try to clean it out and to try to wipe it down and to do different things to it. They were giving her advice on how to, I guess, make sure that the device was working correctly.
And so after, we don't have any violations other than this one day. So did she continue using the same Smart Start mobile device after June 2nd, 2022?
No, sir. If you,
You're muted, Mr. Lopez.
I apologize. No, Your Honor, I will give you the exact date that she made an appointment to go down and take it and have it replaced. If the court will give me just a moment.
Sure, take your time.
Thank you, sir. Just Christian.
Yes, sir.
The company did not have any replacement devices, and so she had to call, and she would call, and eventually on June 23rd, they gave her an appointment to come down and have the device examined. And we're looking right now on her records on when the device was actually replaced. The device was in fact replaced on June 23rd, Your Honor.
Okay, and between June 2nd, which is the alleged violation date, and June 23rd, was she able to blow in the device 4 times a day or not?
I believe she tried to comply, Your Honor. And
well, they haven't alleged any violations during that time frame, which is why I'm asking.
Yes, sir. And we have no explanation for that, but she would comply when the machine required or when she was scheduled to blow into the machine. But whether it was registering or not, we don't know. We think it was offline.
All right, let me ask you this. You mentioned that Ms. Small apparently had to pay $500 for a new device. Is that true?
Yes, sir.
If she was, and this is my understanding of how this rental stuff works, and you can clarify for me in her particular case, but normally when we have defendants who are ordered to go on a Smart Start mobile device, they have to pay an initial, and Susan would know the answer, 150 or 200 or something to get it activated. Is that correct, Susan?
Yes,
And it's like $95 a month after that for the rental fee?
correct.
Okay, so I don't understand where this $500 amount comes from. Did she lose the original device and have to buy a whole new device or what?
No, Your Honor. I believe that what happened was the company made the allegation that because she was honest with the company.
Yeah.
She said the hand sanitizer might have gotten on it. They told her how to clean it out. They held her responsible for the $500 fee to replace the device.
Oh, okay. And since she replaced it at great expense, I might add, we haven't had any more problems. Is that true?
That is absolutely true, sir.
And Ms. Gross, we have recorded no more violations from Ms. Small on a Smart Start mobile device since June 2nd, 2022. Is that accurate?
Judge, I believe there's been one skip test and that's it.
Okay. Okay, I got that part figured out. There's allegations also on what I will call for the record 14. There's 1, 2, 3 condition 14. So I'll call those 14 A, B, and C. In 14C, it talks about her missing 9 breath tests. Is that true? In other words, she gets 4 breath tests a day on this machine, and somewhere in there, she missed 9 between May 13, allegedly, to June 11, 2022.
Your Honor, that was during the period that the device was not working. That was a follow-up to your question earlier. When you said,
That puzzle piece fits perfectly. Good point. Thank you. Okay, so as we speak today, Ms. Small has a properly working Smart Start mobile device calibrated at 4 blows a day. Is that true?
yes, Your Honor.
Ms. Small, is that true?
Yes, sir.
Okay, I got you. State, do you have any questions based on mine?
No, Judge.
State recommendation, please.
State would recommend that, if anything, Judge, that the amount of times that defendant blows in be increased from 4 to 6.
Okay, what the state is requesting, Mr. Lopez, is that in lieu of requiring her to go on a Scram device at $350 a month, that we give her the benefit of the doubt, and the only bad thing, we'll leave her on deferred adjudication, of course. We won't take that away, although we could. But we'll leave her on the device she has now, which is apparently properly working. We're going to increase her blows from 4 blows a day to 6 blows a day. If she shows us a 30-day period of time at 6 blows a day without missing any blows and no high bracks of alcohol, we crank her back down to 4 blows a day. Would that be acceptable to the defense?
If the court would give me just a moment.
Sure.
Your Honor, to be fair to my client, I'm going to ask her to accept this, but also to be fair to my client, none of this was my client's fault. It was an accident. It was an error in the device. I would ask the court to reconsider what's the basis for increasing the number of blows to 4 to 6. Regardless, I'm going to ask it to accept these terms. Judge Christian.
Here's what I'm looking at. I've got, I don't know, 30 years experience with a Smart Start mobile, probably. This court uses more Smart Start mobiles than any other court in the state of Texas. We've had very few problems with the Smart Start mobile device. We have never, ever had anybody put enough or accidentally put enough hand sanitizer on a Smart Start mobile to destroy it, where they make you buy a new device. So that's very, very unusual in my limited experience at this game. So I want to give Ms. Small the benefit of the doubt. Normally, if I really truly believe that she blew a 071, and I don't think the state has proved that beyond a reasonable doubt based on your representations of the problems she's had with this device. But on the other hand, I find it very unreasonable that she was able to get enough hand sanitizer on this device to disable it. So I find that very strange. So that being said, that would be my quick fix. So if that's acceptable to the defense, I'm going to follow the state's request on that one. Normally I'd put her on weekly UAs, but I'm not going to do that in this case, because if she really truly is drinking, we'll catch her at 6 blows a day. And if she's not, then you're right, and you got us, and all she's lost is a little sleep for a month.
Yes, Your Honor. Could you give me 5 seconds?
Would you like to go in a breakout room and chat with her?
No, sir.
All right, take your time. You bet.
Thank you, sir.
Now I'd like to put Mr. Dominic on a Scram. I think that'd be kind of fun to watch.
Yeah.
Mike, when Randy Parker was working with us years ago, he got him to lend him a Scram device, and so we took him drinking every night and happy hour, and it worked perfectly. It really showed he was laid up like a Christmas tree.
Oh man, that measures the sweat or the blood alcohol. In the sweat, right? Yeah.
Yes.
Interesting.
Don't measure Michael's sweat.
It probably doesn't register that high, Diego.
Your Honor, that is acceptable to my client. We will agree to the 6 times a day.
All right, here's what we're going to do. Ms. Small, on call 675-581. The court accepts your plea of not true. I am going to deny the state's motion to revoke your deferred adjudication probation, or you continued on deferred adjudication probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, ma'am? Oh, good answer. Altering and amending conditions of your probation and increasing the daily number of blows on your Smart Start mobile device from 4 blows a day to 6 blows a day. That being said, you will, if you show me a clean 30-day period of time, which could be 31 days from today, wherein you don't miss any blows at 6 blows a day, and you show no high bracs for alcohol during that time frame, I will immediately put you back down to 4 blows a day where you started. I will not know if you've done this. So if you've done this, you got to let your attorney know. He'll let me know, then I confirm it through probation and order it, and we're all good. Any questions, ma'am?
No, sir.
I'm also going to order substantial compliance within 10 days. And what that means is I want her registered for any programs that she hasn't started yet. She may not actually physically be doing them and going to classes, but she'll be registered for them and know when they start and get on the way to doing everything she needs to do, and everybody will be happy. Would that be okay with you, Mr. Lopez?
10 days. Yes, Your Honor.
And that's it. Any questions on either side? State?
Not from the state, Judge. Thank you.
Defense?
None, sir. Thank you.
All right. Good luck, Ms. Small, and thank you, Mr. Lopez and Mr. Dominic and Mr. Nealbach. I've got just like the nitroglycerin detonator team of the criminal defense we got going.
Hold on.
Don't go anywhere.
Oh, we will.
Miss Small, I'm going to be emailing you your conditions on Adobe Sign here in a little bit. Go ahead and sign those and return those back and give your officer a call. Let her know that you were in court this afternoon. I'll send her a message to let her know to increase your testing. And you can just coordinate with her about your next appointment and your new blow times, okay?